still have obligations under human rights implication to not arbitrarily deprive individuals of their
What is this human rights implication you talk about?
Mr. President, these human rights applications are mentioned in my submission, my last submission, which I will proceed to explain. So, first of all, we acknowledge that states enjoy their sovereign authority in which they are allowed to determine their nationality, and as well as the deprivation of it. And this is affirmed in the not-abound case. And however, the not-abound case also, on top of this, also emphasizes that as well as their enjoyment of this right, they also have to, and I quote, they must do so in accordance with international law. And this is further reaffirmed in the Universal Declaration of Human Rights, Article 15, which states that everyone shall have the right to a nationality and shall not be arbitrarily deprived of such right.
So sovereignty is constrained or restricted by international law and human rights, correct?
Yes, Your Excellency.
Okay.
And the United Nations High Commission for Refugee expert meeting on the interpretation of the CRS, paragraph 15, also confirmed that even if deprivation of nationality were to render individuals stateless, it must not be done so arbitrarily. And on top of this, the United Nations General Assembly Human Rights Committee during their 25th session further affirmed that loss of or deprivation of nationality must serve a legitimate purpose, must be the least intrusive means to achieve the desired result, and be proportional.
Does that purpose have to be good? What if it's racist? I'm gonna take all the nationality of all the black people in America. Is that still acceptable?
Your Excellencies, according to the CRS Article 8, there are certain exceptions that are listed inside Article 8.3, which state that state can only deprive individual of their nationality, which render them stateless, only under certain exceptions such as service to a foreign states, prejudicial conduct, and alliance to another state. These are all of high threshold.
Everything else would be arbitrary and illegal.
Yes, Your Excellencies. And because all of these conventions and court cases, it shows that there is a test or certain standard for states to oblige by in order to deprive individuals of their nationality, which include legality, necessity, and proportionality. And this is not only catered to the issues of deprivation of nationality, but to all violation of human rights, which I included in my case, such as the 2022 Krasolina versus Belarus case and the 2016 Androsenko versus Belarus case relating to the ICCPR Article 19 and 21 relating to freedom of speech and peaceful protest, in which the Human Rights Committee both found that in each case, the government have no rights to impose a huge fine or criminalize these human rights activity based on their arbitrary justification. And so, moving back to our first submission, I submit that...
Agent, what if, let's say, a country has a less measures law in which it criminalizes insults against the monarchy, against the king and its institutions, which many countries who are monarchies do have? Then in those cases, is it legitimate for a state like that to deprive its own nationals of their nationality under those laws?
Yes, Mr. President. Well, in such cases, it does happen. For example, in Cambodia, we also have such law, which is included in our domestic law, and we are not a member of the CRS. But nonetheless, the international human rights still have a certain threshold in which states should still oblige by in order to deprive them of their nationality. And inside the Convention on Reduction of Statelessness, Article 8 states that political opinions are considered a peaceful freedom of speech. So just by you expressing that you do not like the monarchy or you do not believe in their way they lead does not mean that they can be deprived of their nationality.
What if the insults against the monarchy constitutes and riles other people, right? And it constitutes a direct insult and injury so much that people rise up against that monarchy in protest, not against, specifically not in favor of the freedom of speech, I mean against their rights being taken away, but more of like the institution of the monarchy itself. Isn't that also another ground for legitimate deprivation of nationality?
Yes, Mr. President, and this I would like to turn the court's attention to the General Comment on Human Rights Committee, specifically regarding human rights and arbitrary deprivation of nationality. In this paragraph 4, it states that the consequences, this is regarding the test of proportionality. It states that consequences of any withdrawal of nationality must be carefully weighed against the gravity and the behavior. And they also mentioned that it may be difficult to justify loss or deprivation resulting in statelessness in terms of proportionality. However, if it leads to the point where the entire citizens start to rebel against the government, which leads to unsafe or lack of security in the state, which falls into CRS Article 8.3.
Which is, again, state 3 for me again. Article 3, what does it say?
I'm sorry?
Please restate what the convention says in Article 3. You just said it's justified under that.
Yes, Your Excellency. In Article 8.3a, 2.2, it mentioned if an individual's conduct is seriously prejudicial to the vital interests of the state. So it would fall under that ground if it seriously hurts the vital interest of the state, which is security of the state. Now, I will move on to continue my first submission, which I will emphasize the importance of the distinction between a reservation and a declaration. So a declaration, according to the United Nations Treaty Handbook, paragraph 3.6.1, is a statement where it simply aims to clarify or interpret without limiting or altering the legal obligation of that state. And this is reaffirmed in Guideline 1.1.1 in United Nations Law Commissions. And this is also, I will bring the court attention to the Egyptian declaration as an example. And here, the Egyptian only simply made a statement in where they reassure all states that they will oblige by the obligation under the 1888 Constantinople Convention.
Agent, why do then states make declarations to conventions?
Yeah, you just
What's the point of it?
say, hey,
If there's
we're
no
gonna do
legal
it.
way.
States make conventions to it too, because conventions can sometimes be broad and vague. So sometimes states have to make declarations to ensure that these are their understanding of such provisions.
And what happens, let's say, if the understanding is incorrect,
Yeah.
according to the
Or-
ordinary meaning of the treaty?
Right. Does it turn a declaration into a reservation?
If their understanding are incorrect, and if it shows that their declaration, their statement, alter the obligation under their provision, it will be considered a reservation. And in Article 19C of the VCLT states that any reservation that are in contrast of the object and purpose of the treaty will be deemed invalid. Now, whereas a reservation in Article 2.1d of the VCLT is a statement where it purports to exclude and modify the legal effects of that certain provision to its application to the state. And this provision specifically mentioned, and I quote, however phrased or named, in its definition of the reservation. This definition focus on substance over form. Even if it's labeled a reservation, like I mentioned, it is still legally a reservation if it alters the obligation under that treaty. And thereby, I submit that the distinction between a reservation and a declaration is important to determine states' compliance to international law. And secondly, moving on to my second submission, I submit that reservation that broaden the grounds for deprivation of nationality that as party to the CRS is invalid. Article 8.1 of the CRS states that no one shall be arbitrarily deprived of their nationality if it renders them stateless. But in Article 8, it mentions exceptions, as I mentioned, such as service to a foreign state, prejudicial conduct, and alliance to another state. Since these provisions and exceptions are already listed, states have no incentive to make reservations to these conventions, and its reservation to Article 8 is also prohibited under Article 17 of the CRS. Furthermore, the United Nations Law Commissioner's Guideline 1.3.3 also clarifies that when a treaty prohibits reservation to
Agent, you mentioned that there is a clause in the CRS that limits the reservation on certain articles of the CRS. Can a state make a reservation to that article and then make another separate reservation to say that they reserve themselves of the obligation under the one that talks about legitimate?
We don't want to play by your rules and then make up their own rules. Can they do that?
My understanding is that can they make a reservation on Article 8, the
Right.
reservation that is prohibited?
Yes.
They cannot, Mr. President.
Why is that?
Because it's also because in that convention, specifically CRS, Article 17 prohibits any reservation on it, but also VCLT Article 19C prohibits any reservation that are contrary to the object and purpose of the convention. And so therefore, reservation that broaden the grounds for deprivation of nationality to states party to the CRS is invalid. Moving on to our third and final submissions, Your Excellencies, I submit that even if states are not party to the CRS, they still have obligation under international human rights law to not arbitrarily deprive individuals of their nationality.
Agent, you have 1 minute left.
Yes, thank you. First, in Narbonne case, they reaffirmed that states have the rights to decide who are their nationals and to deprive them of their nationality, but only under certain only if they do so in accordance with international law, which is reaffirmed in the United Nations, the Universal Declaration of Human Rights, Article 15, and the United Nations High Commissioners for Refugees expert meeting on interpretation of the CRS also reaffirmed this. The United Nations General Assembly Human Rights Committee 25th sessions also lists down what are the tests and standards for states in order for states to be able to deprive individuals of their nationality, which include legality, necessity, and proportionality. And it's not only for nationality issues, but also for other human rights issues in 2022 and 2016 Belarus case. And with these, I submit that states cannot use their sovereign authority to deprive nationality in ways that violate international human rights law. The Narbonne case limits sovereignty through, and with this, I rest my case. Thank you.
Thank you, Agent.